So we have some important news in the battle to end the NFA's restrictions on suppressors. This all comes after the Trump DOJ recently changed their position on suppressors, and they agreed and found that they are in fact protected arms under the Second Amendment. But the Trump DOJ continues to argue that the NFA and its suppressor restrictions can be upheld because it operates as a shall issue permit, and this has broad-reaching implications not just for that ruling, but also for the individual in this case. And now this is heading to the Supreme Court. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. So as I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was recently ruled on by the Fifth Circuit Court of Appeals. And the stakes in this case just got even higher because of what the Fifth Circuit just ordered. This comes in a case called U.S. versus Peterson, and it deals with the constitutionality of the NFA as it applies to suppressors. Mr. Peterson challenged his conviction of violating the NFA based on a theory that the NFA and its suppressor restrictions do in fact violate the Second Amendment. Now, on first review of this case, the Fifth Circuit three-judge panel found that suppressors are not protected arms and they do not trigger the Second Amendment. The Fifth Circuit also recently issued a new decision in this case, and that same three-judge panel ruled that even though suppressors may be protected arms because that was conceded by the Trump DOJ, they still found that the NFA's restrictions do not violate the Second Amendment because they believe under Bruin, the NFA operates as a shall issue permit. That, of course, is a very shocking and concerning ruling by the Fifth Circuit, which has broad-reaching implications. Now, in response to that, in that new ruling, Mr. Peterson was seeking Fifth Circuit en banc panel review, but that was denied. It was also opposed by the Trump DOJ. They did not want the Fifth Circuit to take that case en banc, and ultimately the Fifth Circuit en banc panel rejected that review. After rejecting the en banc panel review, they allowed the mandate in this case to take effect. So that is also impacting Mr. Peterson. Now, in response to that, Mr. Peterson's counsel had said that they're going to seek Supreme Court review, and they also wanted the Fifth Circuit to stay the mandate in this case, because if the mandate was issued, not only does the broader implications of that ruling go into effect, but also individually for Mr. Peterson, there is the potential that he would have to go back to prison even while he has an active cert petition to the Supreme Court. This was brought up as one of the reasons why the Fifth Circuit should stay the mandate, but apparently the Fifth Circuit did not care and they denied that request for a stay, even though Mr. Peterson is taking his case to the Supreme Court. So that was very concerning for the individual in this case, but luckily Mr. Peterson was able to get the district court to issue an order allowing him to remain out on bond pending the resolution of the Supreme Court writ of cert. Now, for those not aware, in this case back in 2022, both federal and state law enforcement officers executed warrants against Mr. Peterson at his home in Louisiana, and there he also had a home-based FFL. There was a federal task force which included ATF agents and 50 law enforcement officers that searched his home and that home-based FFL. The search warrant was based on some issues with 4473s, and then also they claimed that some of the items sold at that home-based FFL were later actually found at crime scenes. But really, out of this entire incident, it is the possession of a single solvent trap that was found in his safe in his bedroom that was not registered as a suppressor under the NFA that really got him into trouble. And they charged him and convicted him of violating the NFA based on that solvent trap. Now, in response to that charge, Mr. Peterson filed a motion to dismiss that charge based on the Second Amendment. But on review, that lower court dismissed that motion. And at that time, he decided to appeal to the Fifth Circuit for reversal. Now, on original review, the Fifth Circuit sided with the then Biden ATF and Biden DOJ. And the Fifth Circuit found in that first ruling that suppressors are not a necessary accoutrement of a firearm, and they are not required to make a gun useful or functional. Mr. Peterson and his counsel then opposed that. They sought rehearing en banc in the Fifth Circuit, but like I mentioned, that was later pulled and found moot, and the ruling actually of the three-judge panel was later removed because the Trump DOJ decided to shift position on suppressors, and they admitted that they are in fact protected arms. But even in that, they also argued that they can still restrict them because the NFA operates as a shall issue permit. And ultimately, on re-review of this case, the three-judge panel still upheld the NFA's restrictions, agreeing that the NFA operates as a shall issue permit, and that is allowed under Bruin. Under Bruin's dicta issued by Justice Kavanaugh in a concurrence, they stated that CCW schemes may be generally permissible if they apply objective criteria like background checks, fingerprinting, and fees. But here the Fifth Circuit actually twisted Bruin and that CCW permit ruling and the dicta there in the case to justify the NFA's registration and taxation scheme. That is why this ruling is so concerning. In essence, this Fifth Circuit ruling and holding here actually stands for the proposition that any permit system restricting two-way rights may be allowed as long as it operates objectively. However, that decision is now heading up for Supreme Court review. And originally, Mr. Peterson and his counsel were seeking en banc panel review, like I mentioned, but that was quickly denied. And then the Fifth Circuit also decided to issue a mandate in the case, allowing the ruling against Mr. Peterson to go into effect. In response, Mr. Peterson and his counsel asked for the Fifth Circuit to stay that mandate because of the impact it would have on him, where he would need to report back to prison because he was only allowed out on bond while there was an active appeal going on, and he asked for them to stay that. He argued that there would be a clear injury to him because he's going to the Supreme Court, he's appealing this to the Supreme Court, and that he wanted to be allowed to still be out on bond because there's an active appeal. But unfortunately, the Fifth Circuit decided to deny that stay, even though it was unopposed. The Trump DOJ agreed. They did not oppose that. They said it's fine to put the stay in place to allow him to remain out on bond. But again, the Fifth Circuit denied that. So the Fifth Circuit was not being helpful at all when it came to this two-way effort. So Mr. Peterson, in response to that, decided to go back to the district court and ask for the same type of relief. He wanted to remain out on bond, to still be released, and his release to be extended pending the resolution of his Supreme Court petition. And luckily, the district court granted that motion and allowed him to stay out on bond. Now, in that order, they stated that it is hereby ordered that George Peterson shall remain on bond under the same conditions and with the same stipulations as originally set by the court, pending resolution of his petition for a writ of cert to the United States Supreme Court. So that is good news, and Mr. Peterson got that win, and now this critical suppressor challenge is going to head for Supreme Court review. We will see now how this plays out in the Supreme Court and ultimately if they decide to step in, because this again has broad-reaching implications about treating the NFA as a shall issue permit scheme under Bruin that would impact the NFA, but also potentially open the door for a lot of other two-way restrictions where maybe the states or the federal government themselves can put in place restrictions and say, well, we're using it and we're operating it as a objective shall issue permit. And that has a lot of concerns with something like that happening. We've already seen some states try to do things like that with firearms permit systems that they put in place. And if the Fifth Circuit ruling is allowed to stand, well, then that allows them to have an analog or some sort of other circuit justification for what they're currently doing. So this is heading for Supreme Court review, but unfortunately, the Trump DOJ has been very firm on their NFA stance. They've been defending the NFA from multiple angles, and I don't anticipate that they're going to switch their position on the NFA in this case. We've seen them defend the NFA in cases like Rush and Robinson dealing with SBR restrictions. So I anticipate they will do the same thing, but one of the interesting things in this case is that they already conceded that suppressors are protected arms, and for the purposes of this case, that then would be in front of the Supreme Court. So unfortunately, that's where this case currently stands. Now we're going to wait to see what happens at the Supreme Court level, but as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.